The first major federal gun safety legislation in decades is now moving forward. Any law enforcement officers in California, including feds, you are absolutely prohibited from enforcing restricted magazines ownership in California, regardless of when they were purchased. Now, this is the most significant Second Amendment ruling in more than a decade. The Supreme Court has made a decision on the first major Second Amendment case in decades. Not giving notice, well, that's required. And when you don't, you take that away from people. You don't follow the rule and process, and you have to invalidate the rule. My response to that is that's the same claptrap that they have been using for 20 years. The Supreme Court just did something that could change everything about gun ownership in America. Last Friday, they held a conference on cases that could determine whether millions of Americans can legally own AR-15 and standard capacity magazines. And what happened next has everyone on edge. Here's what's at stake. Cook County and Illinois and California have essentially declared that some of the most popular firearms and magazines in America fall outside constitutional protection. They're saying the Second Amendment doesn't cover these items at all. The Supreme Court had to decide whether to hear these cases, and the decision they made has massive implications. Let me break down exactly what's happening, because this affects every gun owner in America. The main case involves Cook County's ordinance that makes it a criminal offense to sell, transfer, or even possess what they call assault weapons. Think about that for a second. Items that millions of Americans legally own could become contraband overnight if this stands. This is big. Breaking news from the State House, one of the big bills in front of the Senate for the Supreme Court. It's all about language. Reasonable suspicion, objective, reasonable belief, or probable cause. A 3-judge panel ruled that the state's ban on magazines holding more than 10 bullets strikes at the core of the right to bear arms. Red Dot Optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better. And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun. This is not a gun decision. No, it's not. This was not decided on Second Amendment grounds. It triggers something in me that something has to be done. The timing of this couldn't be more critical. Justice Kavanaugh recently made a statement that caught everyone's attention. After the court declined to hear a rifle ban case last term, he specifically said the time would come very soon when the Supreme Court would need to address this issue. He mentioned it could happen within a term or two. Well, that time might be now. The plaintiffs in these cases include individual citizens and major Second Amendment organizations who are pushing hard for the Supreme Court to fulfill that promise. They want a definitive answer to a simple question. Does the Second Amendment protect the right to own semi-automatic rifles and standard capacity magazines? Now, here's where things get really interesting. The path to the Supreme Court started back in 2021 when the rifle ban lawsuit was filed in federal district court in Chicago. While that case was working its way through the system, Illinois passed a statewide assault weapon ban in 2024. This created an overlapping web of restrictions that affected millions of gun owners. The Seventh Circuit Court made a ruling that sent shockwaves through the gun community. In a case called Bees versus Nepville, they upheld Illinois' law by claiming that AR-15s were too militaristic to receive constitutional protection. Their reasoning, they said firearms useful in military service could be completely banned. This logic would essentially gut the Second Amendment, since many common firearms have military applications. But public safety concerns must be addressed in ways that are lawful. This rule is not. The Supreme Court today handed down a major victory for gun control advocates, that declaring various federal gun restrictions unconstitutional in the state. Panel's majority ruled Friday that the law banning magazines holding more than 10 bullets violates the constitutional right to bear arms. This is an issue that every gun owner should be concerned about, and we in Congress should be concerned about it too. A federal judge ruled California's ban on magazines that can hold more than 10 rounds is unconstitutional. State can't make everywhere a sensitive place. You can't go hiking in some places and not be able to defend yourself against somebody that you run into. It's a case that legal experts will be watching closely. The district court, bound by what the Seventh Circuit had already decided, upheld Cook County's rifle ban. They issued a summary judgment in favor of the county. And in 2025, right after the Supreme Court declined to review another rifle case, the Seventh Circuit doubled down. They affirmed the lower court ruling and leaned heavily on their previous decision, treating AR-15s as civilian versions of M16s and therefore outside Second Amendment protection. This is where the petitioners stepped in with a direct challenge to the Supreme Court. They're asking the highest court in the land to resolve this once and for all. Do Americans have a constitutional right to own AR-15 and similar semi-automatic rifles that states are trying to ban? Cook County's response reveals their strategy. They're arguing the Supreme Court should ignore this case entirely. Their reasoning is threefold. First, they claim there's no circuit split on whether these rifles are protected. Second, they argue this case is procedurally flawed because the plaintiff supposedly rushed to the Supreme Court without following proper procedures. They claim the plaintiff skipped discovery and didn't provide admissible evidence. Third, Cook County maintains the lower courts got it right on the merits. But here's what makes this fascinating. Both the Cook County rifle ban case and a California magazine ban case called Duncan versus Bunt went to Supreme Court conference last Friday. The Duncan case has an interesting history. The Supreme Court already granted, vacated, and remanded it based on their landmark Brewing decision. But like many Second Amendment cases, the lower courts didn't properly apply the Supreme Court's guidance, leading it right back to the highest court. And today we got a crucial update. Both cases have been relisted for another conference on December 12th. Want to see Congress pass laws that will help reduce crime without infringing on the rights of law-abiding citizens? The government may not regulate individuals' possessions of weapons for self-defense. There's nothing in the Second Amendment that says that you can ban magazines or any crucial part of a firearm. If a magazine can be considered an arm or not, the attorney representing could be used to strike down the entire ban, which would allow Californians to buy high-capacity magazines. Gators Custom Guns in Collin County argue that magazines are essential and a common part of a firearm, therefore a protected right. It also puts state laws in jeopardy that are similar to this law. Now, if you're wondering why a relist matters, here's the critical insight. Supreme Court analytics show that cases have significantly higher odds of being granted review if they're relisted at least once. The data is compelling. Looking at the court's patterns from 2016 to 2020, between 31 and 43% of petitions relisted only once were eventually granted review. Even more telling, between 66 and 75% of all cases the court agreed to hear were relisted at least once. A single relist often indicates the justices are seriously considering taking the case. However, there's a flip side to this coin. Multiple relists, like what happened with the recent Maryland rifle ban challenge, typically signal bad news. The more times a case gets relisted, the lower its chances become. Multiple relists often mean the case will be denied, possibly with one or more justices writing a dissent or statement. So where does this leave us? The Supreme Court has historically avoided rifle and magazine ban cases. They've had multiple opportunities to address these issues directly and have declined each time. But with Justice Kavanaugh's statement hanging in the air and these cases being relisted once, there's genuine reason for both hope and concern. The single relist isn't necessarily bad news. In fact, it could indicate serious consideration by the justices. But if we see these cases get relisted multiple times at future conferences, that would be a strong signal they're headed for denial. Major decision from the Supreme Court that could have larger implications on gun laws nationwide. There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense. They really don't know what to do with this one, which is always a good thing to see. The Second Amendment protects the right to carry a gun in public for self-defense. Even if you are innocent, your words can still be twisted and taken out of context. Will allow scrutiny for all gun laws pertaining to everything: assault weapons, age restrictions, restrictions on magazines, topics ranging from gun rights and private property laws to foreign property confiscation. This is currently the rule until they decide to change their minds, which they inevitably probably will. What makes this moment so pivotal? is the broader context. States across the country are watching these cases closely. If the Supreme Court takes them up and rules that AR-15 and standard magazines are protected by the Second Amendment, it would invalidate bans in multiple states. If they decline to hear the cases or rule against gun owners, it could embolden more states to pass similar restrictions. The December 12th conference date looms large. After that conference, we'll get another update on whether these cases move forward, get relisted again, or receive a final decision on whether the court will hear them.